Hello and welcome to Know Your Rights YouTube channel. In COVID-19 series, today we are going to talk about legal issues in relation to payment of rents during lockdown. As we all know, since 25th of March, the country has been under a nationwide lockdown, which essentially brings about two sets of issues. One, payment of rents by students, migrant workers, temporary laborers who have occupied temporary accommodation in different parts of the country, who have probably also compelled to continue to stay in the places where they are staying right now in view of the lockdown that has been announced by the government. The second issue is in relation to payment of rents for shops, offices, and other commercial premises where these people have been restricted to have an access or to operate from these commercial premises, still be now asked to consider to pay rents for that premises. Let us look at the position in law right now. All the contracts in general under Indian law is governed by the Indian Contract Act 1872, where there is a concept of doctrine of impossibility or a doctrine of frustration under section 56, which essentially gives to a situation where two parties enter into an agreement to perform certain kind of obligation, and those obligations for some events that are not within their control becomes impossible or unlawful, then that contract becomes void. This is a doctrine that has been largely applied by various commercial entities in terms of their commercial contracts. But while we are talking about the issues in relation to rent specifically, the Transfer of Property Act provides for certain rights and liabilities of lessor and lessee. Now, since these provisions are specific to the transfer of property, which is one specific set of the contracts, there has been judgments by the Supreme Court of India to say that Section 56 of the Contract Act will not apply to a lease and rights and obligations of lessor and lessees are concerned. So if you see the section 108, which is a lot more limited than what is there under section 56. So it will apply only if there is a situation of fire, flood, violence of an army or mob, or some other irresistible force, which essentially leads to a situation of the property being wholly destroyed or rendered substantially and permanently unfit for the purposes. So this section per se does not grant any person a right in relation to a situation like a pandemic, COVID-19 pandemic. So per se, there is nothing under law that gives the right not to pay rent or to kind of hold the money back for the time in a situation like COVID-19 pandemic. Besides these provisions of law, every contract has to be governed by the contractual terms, specifically what is there in that particular contract, and usually one has to refer to a clause which is there in many of the contracts called as a force majeure clause, which means an act of God. However, in most of the leave and license agreement, if you will see, this is not a common practice to have a force majeure clause, but one has to look at that individual contract to see if there is any force majeure clause and what does it really cover. Does it cover a situation of a pandemic, and what is the consequence of that being covered? Does that give any right to kind of hold the rent or not pay the rent for that time being? In this legal background, let us look at the current issues in India. Payment of rents by students and migrants and other temporary laborers has been a serious issue currently. In Delhi, for example, there has been a union formed between the students from University of Delhi. There were 3 to 4 lakhs students are staying in small rented places where the landlords have been now compelling them to pay rents. Uh, this is kind of a situation that is happening across the country. There is no specific law that kind of provides these tenants any kind of reliefs. However, there are these guidelines. For example, Ministry of Home Affairs has released an order on 29th March 2020 stating that the landlords should not be asking for rents, at least they should be suspending these rents for a period of month at that point of time when it was released. But despite these orders and guidelines, and there are also been various advisories from different state governments, for example, state of Maharashtra and state of Delhi had requested the landlords not to charge rents from these students and other migrant laborers at least for a limited period of time. Delhi government even went one step ahead and said that in case if the tenants are being unable to make any payment of rents, the government will pay for it. But unfortunately, these guidelines and advisories are all in the form of being just as a suggestion to the landlords and a request to the landlords, and there is no law that compels them not to collect the rent or to suspend the rent for a period of time. This does not bind them at all. In fact, some of the people have approached the Supreme Court stating that this Ministry of Home Affairs order needs to be implemented vehemently across the country. However, Supreme Court said that this is a policy decision of the government. We will not be able to implement it, and then they dismissed that PIL also. So currently there is no law, there is only advisory. These advisories are not binding on the landlords. Similar case with the rent by the commercial premises situation, all the shopping malls and complexes where people have occupied, unless their contract specifically provides that in a situation like this, rent need not be paid or that it can be suspended, the rents need to be paid. However, what we are seeing is that in many of at least the urban metropolitan cities, there are renegotiations that are happening between the landlords and tenants in relation to the commercial premises. Both the parties, particularly understanding the current peculiar situation, they're re-looking at the contract. Though there is no legal right, parties can kind of sit together and discuss, renegotiate, and they can enter into a supplemental or an additional agreement which will provide for some kind of relief for the tenants in relation to these rents. Uh, while India does not have any specific law that provides relief, Singapore, for example, has come up with this COVID-19 Temporary Measures Act, which provides various set of reliefs. One of the reliefs is that within this period of 6 months, in case if any of the tenants are being unable to pay rent, the landlords will not have any right to evict such tenant. Such kind of legal remedies are not granted in India, but this is what we have as a current legal position. So with this, we come to an end for this episode. If you have any suggestions or comments, please do comment on it. Thank you.